Ladies and gentlemen, here's a very hearty good evening to all of you. Welcome to the Act and its Impact, a knowledge update series on the Companies Act 2013. And this edition is on the repeal of SICA, or the SIC Industrial Companies Special Provisions Act 1985. As you may all be aware, the SIC Industrial Companies Act was brought into force to enable the revival and rehabilitation of SIC industrial companies. We had a board for industrial finance and reconstruction. There would be an operating agency which would be appointed to walk the company through its revival process and so on. And references could be made based on a balance sheet criteria of net worth erosion. Somewhere along the line, it was widely felt that SICA was not really working, and that SICA was used more as a tool to delay payments to creditors. So the government came up in 2003 with the SIC Industrial Companies Special Provisions Repeal Act 2003. But for various reasons, this repeal could not be notified. So SICA continued to operate. However, on November 25th, 2016, we've had two notifications, 3568 and 3569, from the MCA, which seek to notify the SICA Repeal Act with effect from December 1, 2016. So what happens if the Repeal Act is notified? The original act is over, which means we've actually bid adieu to SICA. Now, I'd like to draw your specific attention to a particular section 4B of the Repeal Act. It's a section that's been amended by the Insolvency and Bankruptcy Code. And let me read this section for you. On such date as may be notified by the central government in this behalf, any appeal preferred to the appellate authority or any reference made or enquiry pending to or before the board or any proceeding of whatever nature pending before the appellate authority or the board under the SIC Industrial Companies Special Provisions Act 1985 shall stand abated, provided that a company in respect of which such appeal or reference or enquiry stands abated under this clause may make a reference to the National Company Law Tribunal under the Insolvency and Bankruptcy Code 2016 within 180 days from the commencement of the Insolvency and Bankruptcy Code 2016 in accordance with the provisions of the Insolvency and Bankruptcy Code 2016. Provided further that no fee shall be payable for making such a reference under the IBC 2016 by a company whose appeal or reference or enquiry stands abated under this clause. So what does this section mean? It means that all proceedings under SICA are abated. And if you have a client who's at any stage of SICA, then especially once their case is numbered and there's either an enquiry pending or yet to be heard or orders passed, then since their proceedings are abated, if they want to go through the BIFR route, they have to come and make an application to the National Company Law Tribunal under the Insolvency and Bankruptcy Code. So this is very important. If you have clients under SICA, please take care and please note this change. Now, what's this Insolvency and Bankruptcy Code all about? In the next series of updates, I'll start speaking about this new code, which promises to be a fairly large professional opportunity and a completely dramatic and decisive change in the insolvency resolution space in India. Please stay tuned. The Act and its Impact from the Smart CA series. Thank you very much.